Well, in an ideal world, a seller, a buyer, agree a price for a property and the keys happily transfer from one to the other on settlement day. But in the real world, people change their minds, buyers come up short with funds, or the seller leaves the property damaged. Property lawyer Jeremy Streten from Streten Masons Lawyers and the author of The Business Legal Life Cycle is here to answer all our questions about what happens when a contract goes wrong. Jeremy, thank you so much for coming on the program again. We really appreciate your patience. I guess just firstly, if we sort of throw some, I guess, challenges or situations at you, what options does a seller have if a buyer comes up short of funds on settlement day?
Yeah, thanks for having me on again, Bridie. So basically a seller has a few options. So the buyer would be in breach of the contract, and then the seller would have the option to either allow the buyer to extend settlement if they thought that they could actually come up with the funds at a later time, or they can actually terminate the contract and then resell the property. And then they can actually, if you resell the property for less money or it costs you extra money, then you can, as a seller, sue the buyer for your loss of resale price and your costs of doing that, so lawyer fees, agents' fees, and all those kind of things.
I'm wondering, Jeremy, how often is it happened that this, it's delayed or that the contracts crash?
Yeah, it's a great question. I think that the rate that it happens is very minimal. They're the ones and the matters that actually take up the most amount of our time as lawyers. But the vast majority of contracts settle on time and without any problems. The main problem that seems to happen is when people don't get finance or their property doesn't stack up to the price that they've paid for it. So I would say, out of every 100, you'd probably have 3 or 4 that fall over, and probably of those, 80% would be because they didn't have the money to actually settle it. But it's very rare.
Obviously, it must be a very stressful time when something like this happens. How important is it to sort of get legal advice? Because are there certain, time frames and particular legal processes that need to happen?
Yeah, I think this is one of those areas where it's very easy, because problems don't come up very often, it's very easy to think that you don't need legal advice, but it really is important. And I don't just say that as a lawyer. It's very easy. People could be cynical and say, I'm a lawyer, so of course I'm going to say you want to speak to a lawyer.
Yes.
But in all seriousness, it is very important, because every contract is different. There are different terms, there are different conditions, and you need someone who knows what they're talking about, can read it, can understand from a legal perspective, and to give you advice on what to do from a legal point of view. So you can always get advice from others about the commercial aspects, and you should get advice from your lawyer about the commercial aspects as well. But I think it's critical that you always talk to your lawyer, because if you don't, then you could set yourself up for failure.
Well, I'm happy to promote you as well as lawyers, because I've sold and bought a few times over the years, but particularly because you understand the weird language, the jargon, the things that we don't always understand. I'm wondering if you can explain default notice and rescission notice.
Yeah, so those are not really used in Queensland. So anyone who's watching this in Queensland, that's not really a term. But in other states like New South Wales and Victoria, if you are in default of a contract, say if you're a buyer and you're in default, then the seller can serve a default notice on you to say that if you don't remedy that default, and the time is usually 14 days, that they can terminate the contract. And that's what a rescission notice is. So that's actually the termination of the contract if someone hasn't fulfilled their conditions and fulfilled their default.
I guess it'd be easy to assume as the seller that you automatically get to keep the deposit if the buyer doesn't fulfil the contract. Is that necessarily the case, though?
It's not automatically the case, although it's the great lawyer answer, it depends. It depends on what the contract says. So if the contract says that the seller can keep the deposit, which it normally does if the buyer defaults, then yes, they can keep the deposit. But for things in Queensland, the standard contract says if you can't get finance approval, then the buyer gets their deposit back. But if they don't settle, then the seller gets the deposit. So it really depends on what the actual contract says. But most of the time, yeah, the seller would get the deposit in that situation.
Sure, and you mentioned suing before and then the deposit. Is that the damages or costs is the deposit, or is there other things that can be sued for? And do you have to do that to go, do you have to go through the process of suing?
You don't have to go through the process of suing. If you're happy with the deposit, so if you're a seller and the buyer defaults and you take their deposit and you say that's enough for me, I'm not going to try and pursue them for anything more, then that's fine. In Queensland, you can definitely sue for more. I know in some of the other states you can as well. I haven't looked at every single state, but you can definitely, if your loss is more than 10% or more than the deposit that you held, you can definitely sue for more than that. But if the person can't get finance, you don't sue someone if you're not going to have the money at the end of the day to recover from them. So it may not be worthwhile pursuing them, and you have to look at that from a commercial perspective.
Yeah, I guess from the buyer's point of view, the basic rule of law is still that caveat emptor, the buyer beware, right? So, I mean, it does kind of seem that the law is very much in favour of the seller when it comes to the sale of residential property in Australia.
Yeah, absolutely. And the buyer's given lots of opportunities to do their inspections. So you have your opportunity to get a building and pest inspection done. You've got an opportunity to check everything to do with the property, your boundaries, do all your searches. That's why you come and see a lawyer. We talked about that earlier about people thinking they don't need to see a lawyer. Well, the lawyer knows all of those things that you should get done to make sure that you buy the property and you don't fall foul of those rules. Because if you haven't discovered something that's wrong with the property and the seller hasn't told you about it, it is buyer beware, and you could lose out and lose a lot of money.
Yeah, it's an important little bit of Latin, isn't it? And I'm wondering, you tell people to do those inspections. How important is it for buyers to carry out that final inspection before settlement?
Oh, very, very crucial. We always encourage them to do it, and if they're not in Queensland, we encourage them to get a trusted friend or someone else to go and do the inspection, because you don't know what is wrong with the property. Often when they do a building and pest inspection, they won't, say, remove furniture.
Yes.
And so you may not know that there's damage behind the furniture. Usually on the day of settlement, that furniture will be removed and you'll be able to see it. And if you do it then, you'll find out about it.
There's a big crack behind the cupboard in bedroom 2.
What valid legal reasons does a buyer have to walk away from a contract that they have signed?
Yeah, well, so again, in Queensland, which is my specialty, usually a contract will be subject to finance or building and pest inspections, and then being satisfied with both of those conditions. So that would be a valid reason to walk away. If you found that there was something wrong on the day of settlement with the property that was a really bad problem, then that might be grounds to walk away. Again, it depends on what the contract says. But if there's something really wrong with the property, then you can. But once you've paid your money, really, you don't really have any other choice. You've bought the property, and if you want to try and pursue the seller, then you'd have to do that for damages after the fact, which was very difficult and very costly.
I've heard of stories, where people have dumped lots of things in the property, and they've left old furniture and broken down trailers and stuff like this on the property when they've sold, things that maybe weren't noticeable during the inspections. What recourse do you have in that point?
You really have no recourse. So you go and do your final inspection. If there is stuff left in the property, the contract in Queensland, the standard contracts that are used say that property, if it's left on the property, is deemed abandoned, and you take it on as a buyer. I actually fell foul of this when I bought a house about a decade ago. Being the trusting young lawyer, the sellers were there cleaning up their house. When I went to do the final inspection, they told me they'd finish it 6 hours before settlement. I turned up after settlement and they'd down tools straight away and left it in an absolute mess. So I always tell people that story to say, even the best of us can fall foul of that. Don't trust people. Go and check it to make sure that it's actually clean beforehand.
And I guess this wouldn't happen very often, but have you ever heard of, or what happens if a seller changes their mind about selling after signing a contract, but before settlement, say, I mean, you don't know, but maybe they've got a better offer that they're not telling you about, but they want to walk away. I mean, what does a buyer do in that situation, especially if they've spent money on inspections and, the building and the pests and all the rest, and, legal fees, that sorts of thing?
Yeah, well, in Queensland, once the seller signed the contract, really they have very little rights. They have to settle if the contract is signed and if the buyer comes up and pays the money at the settlement. In other states, you have the concept of exchange, where you have to exchange contracts, and until that exchange occurs, the seller can actually walk away. So it does vary from different states, but it's very hard once either the contract's signed by the seller or exchange has occurred for the seller to walk away. And if the seller does try, then unfortunately there are costly remedies through the courts, and they're really the only ways. You can actually go to court and get an order that the seller sells and settles the property, but it does cost a lot of money. Yeah.
Oh, look, it's always great to get your thoughts on all these property law matters. Jeremy, really appreciate your time. Thank you so much.
Thank you so much for having me.
Jeremy Streten there from Streten Masons Lawyers and the author of the Business Legal Life Cycle. We're going to take a quick break. We've got an auction to get to coming up in Colonel Light Gardens in Adelaide.